Judicial powers. Unlike the legislative and executive departments, the judiciary has no specific qualifications for office. The Constitution in Article 3 states that judges shall hold their offices during good behavior. The Supreme Court is the only court established by the Constitution. Lower federal courts are established by Congress. Even the size of the Supreme Court is not defined. It has remained at 9 sitting justices in modern times, although the number has been as low as 5. Franklin Roosevelt attempted to pack the court in 1937 after the court ruled a number of his New Deal acts unconstitutional. Congress rejected the attempt. Terms of office for Supreme Court justices, by extension of the description of service, is life after appointment. Typically, Supreme Court justices come from other federal judgeships. The appointment process has become more and more difficult as the results of close questioning by the Senate Judiciary Committee. Appointments by Richard Nixon were turned down. One of the most publicized confirmation hearings took place when George Bush sent Clarence Thomas's name to the Senate, and he was accused by Oklahoma law professor Anita Hill of sexual harassment. In addition, nominees are also questioned on their attitudes regarding potential issues the court may have to rule on, such as abortion. Nominees must tread a very thin line during this process and must not be too specific. They must avoid creating a conflict that would arise if they rule on a case they have already spoken about. The major power given to this judicial branch is defined as the judicial power, which shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made. The real power, that of judicial review, has grown in importance throughout the history of the court. Specific cases and the role of the court in American life will be discussed in Lesson 9, the Judiciary. The Constitution describes cases through original jurisdiction that the court can hear directly. The vast majority of cases heard in the Supreme Court are brought on appeal from state and federal courts. This is called appellate jurisdiction. Congressional law, as well as presidential actions, have also been taken up by the Supreme Court. It is interesting to note that of the 3 branches of government, the Supreme Court has no direct responsibility or accountability to the voters. Sitting justices, once confirmed, decide on cases based on their own interpretation of the Constitution. The impact of the Supreme Court on policymaking has increased in modern times. Many court experts point to the landmark decision of Brown v. Board of Education as a turning point in the history of the court.